Okay, this is video lecture number 1 on the writings chapter of your book. This series of video lectures will cover the entire chapter, which is actually a short one, pages 669 to 696. So part A of the chapter covers the concept of the best evidence rule. So to start with, this phrase best evidence rule is very old, and really the phraseology is a little misleading. The federal rules covering this are rules 1001 through 1008. So basically all of the rules there in Article 10. And I'm pretty sure these rules don't even use the phrase best evidence rule. But it's been around so long that it's the shorthand people use when the issues discussed in these rules come up. So the first thing to note about it is that there is no general requirement that a proponent of evidence offer the quote-unquote best evidence available. For example, evidence that fits a Rule 803 hearsay exception is admissible, even when the actual declarant, for example, might be available to testify. And certainly we'd probably all agree that testimony by a live witness would be arguably better evidence than the hearsay statement itself. Or if there's an object that is important in a case, there's in fact no requirement that the actual object be offered into evidence. A proponent can put on a witness to just describe the object, even though again, arguably it might be quote unquote better to have that object in the courtroom. Okay, so keep that in mind. No general rule of presenting the best evidence possible in every situation. So as the title of Article 10 makes clear, in the modern incarnation of this rule, the best evidence rule applies only to situations in which arguably inferior evidence is being offered in lieu of an original writing, an original recording, or original photograph. And this is very important. This is true if and only if it is offered to prove the content. So the easiest example of the application of the best evidence rule comes up when a witness seeks to testify about the contents of a document, say, without producing the original. So we've got a witness wanting to testify about the contents of a document without producing the original. So we see that these rules in Article 10 require either that the original be produced or there be a valid excuse for not producing that original, or lastly, a showing made that that document isn't closely related to a contested issue in the case. However, as you see down here, this is a very big however. Under Rule 1003, we see that a duplicate, such as a photocopy, almost always can be substituted for the original, even if there's no excuse for not producing that original. Okay, so in modern cases, the discovery process and other pretrial processes usually are going to resolve questions about what documents, recordings, or photographs and what substitutes for those documents are going to be used at trial. But occasionally the best evidence rule will come up at trial in a low discovery case, right? A case where not very much discovery was done, or when a lawyer isn't well prepared, or when someone is surprised by the trial testimony of a witness who all of a sudden starts to try to testify about the content of one of those items. Okay, so from a practice standpoint, you should know that the best evidence objection is different from other objections that might also be made to a writing. And when I use the word writing or document here in this section, you can assume it also applies to recordings and photographs. So even if the writing is not hearsay, and even if the witness has laid the foundation for a finding that the writing is authentic, which of course authentication is covered in the other section of this chapter, the best evidence rule actually potentially gives a lawyer a separate basis for objection. So let's imagine some hypothetical testimony here. Our hypothetical case here is a contract dispute between the witness on the stand. So the witness on the stand is a party in this dispute, and the other party is Mr. Bushmat. Okay, so here we have the witness's lawyer doing her direct examination of the witness, the party opposite Mr. Bushmat in the suit. So she's questioning her own client here. So the witness's lawyer said, "And did you hear from Mr. Bushmat after that initial conversation?" The witness says, "Yes, I got a letter from him the next day." The lawyer says, "And what did the letter say?" And boom, all of a sudden, Bushmat's lawyer stands up and says, "Objection." Okay, so let's stop right there. Bushmat's lawyer didn't say why he was objecting, but there are at least 3 possible bases for objection to this last question, right? The first is a hearsay objection. Of course, letters and other writings are indeed out-of-court statements that must satisfy the requirements of the hearsay rule if they are offered for their truth. But we know Bushmat is the opposing party here. He is purported to have in fact written the letter. So let's assume the letter overcomes the hearsay ban because it is an admission, right? A statement of a party opponent. So classified as not hearsay under that exemption in Rule 801 D2. Okay, so let's move on to the next possible objection, which is authentication. As you saw in the latter part of the chapter, there needs to be a sufficient foundation laid to justify a finding that the letter actually came from Mr. Bushmat. But as you saw in the reading, the requirements for laying that foundation, that a writing is what the proponent says it is actually a pretty low hurdle. So for example here, the requirement of authentication could be met by having the witness just testify that she recognizes or recognized Mr. Bushmat's handwriting or signature on the letter, maybe because she had gotten previous correspondence from him, or some other possible means of authentication that we'll discuss later. But let's assume that's the case, that we've got adequate authentication here, so that objection is not going to work either. Still, because the witness is being asked to testify about the content of a letter, and that letter hasn't been produced, there is one more possible objection, and that is the third one, best evidence. So even if the letter is not hearsay, and even if the evidence has been produced sufficient to support the finding that it came from Mr. Bushmat, even if we've got that evidence, an objection should still be sustained on grounds that oral testimony about the contents of the letter is not the best evidence. Okay, so hold that thought and let's look at how the rules actually would dictate whether this best evidence objection to the letter would be sustained. First, Rule 1002 sets forth the basic requirement that unless otherwise provided in the rules, the contents of a writing, recording, or photo must be proven by producing the original. That's the basic rule. Then, though, Rule 1003 follows right after that to say, oh, by the way, a duplicate is admissible in lieu of the original, unless for some reason the authenticity of the original is in dispute, or for other reasons, use of that duplicate would be unfair. Now, when looking at this word unfair in the rule, a good example of a situation in which it might be unfair to admit a duplicate would be if it was a bad copy, for example, an illegible or blurry copy, etc. So remember that we're dealing with writings, recordings, or photographs here. So duplicates can obviously include a re-recording, right, of the original recording, or a photocopy made on a copier, or a copy of a photo. Now, next, Rule 1004 would give the witness's lawyer the ability to make the argument that the original or a duplicate couldn't, in fact, be produced for one of these reasons. First, maybe all the originals have been lost or destroyed, and not lost or destroyed by the witness party acting in bad faith. Or maybe the argument could be made that the original can't be obtained by any available judicial process, just can't get the original. Or C, maybe the party against whom the original would be offered is actually the person or party that has control of the original. And in fact, if that party was at that time put on notice by pleadings in the case or otherwise that that original is going to be a subject of proof at the trial, if that person failed to produce it at the trial or hearing, that would also be a potential excuse. Or lastly, maybe the writing, recording, or photograph can be argued to be not closely related to a controlling issue in the case. So those are all the possible excuses for not producing an original or duplicate. And here in our example, probably the only excuse applicable is going to be this 1004A excuse, that the original of the letter was somehow lost or destroyed inadvertently, for example. But even if it wasn't inadvertent destruction, then for some reason, some excuse that does indicate that the party that wants to present the oral testimony about the letter wasn't at fault, didn't lose or destroy it in bad faith. Okay, let's talk just for a second about the underlying goals of the best evidence rule as it came up through the common law. Obviously, first, major goal, prevention of fraud. For example, it's easier to make a convincing looking copy of something that doesn't replicate the original exactly, right, than it is to actually alter the original in a way that would be convincing looking. So there's a concern that the proponent of the evidence might be purposefully suppressing the original in order to put in a copy that could be altered, or in fact just using false testimony about the contents of the original. So that's obviously one concern. Another old school goal really goes back to the old days when copies of documents were made by hand, and that is the goal of avoiding unintentional mistakes in copying. Not a big concern in modern times, obviously, when we have photocopiers. But the other goal of avoiding good faith errors in testimony certainly still remains. So someone who's offered as a witness to testify about the contents of a writing could have, for example, maybe just barely skimmed that letter, maybe misunderstood what the person was really saying in the letter. So arguably, as a policy matter, it might be better to have the actual letter or an accurate photocopy. So the federal rules aside, I think we can all agree that the document itself, the photograph itself, the recording itself is going to be technically better proof of its contents than any secondary evidence. And the best evidence rule gives the proponent an incentive to produce this better evidence. But it's important that we remember that with regard to secondary evidence, right? Remember that if a proponent satisfies a judge that the original is missing or that there is some other valid excuse for not producing the original under Rule 1004, the proponent then will be allowed to prove the contents of the original either by oral testimony or by producing a copy. And either way, you can still prove it by testimony. All right. Now, the one wrinkle here in that general overarching rule concerns public records. So Rule 1005, the text of which I have up here on top of the slide, definitely expresses a strong preference that if you're trying to prove the content of a public record, there's this strong preference that you provide a certified copy if it's possible to get one, or at least testimony by someone who has compared whatever copy you present very, very carefully with the original public record. And as set forth in the rule, the proponent here of a public record kind of document is only going to be able to offer other evidence of the content of an official record, i.e., especially proving it just by testimony, if the party can show he or she exercised due diligence in trying to actually get a better quality of evidence to offer there. And by the way, just to connect up a couple of other rules here, if a party complies with Rule 1005, say, and produces a certified copy of a public record, we have to keep in mind that the party here is also going to have automatically satisfied the authentication requirement of showing the copy to be what it is claimed to be. And that is a requirement we're going to talk about next. And that's right there in Rule 9024. Okay, so if you have a certified copy, it automatically is authenticated, but don't forget that in order for a public record to be admissible under the public records exception to the hearsay rules, it also has to satisfy the requirements of Rule 8038, the hearsay exception for public records. At the time I'm recording this, we haven't covered that rule yet in class, so if you're listening to this prior to us covering the public records exception, this will all connect up for you after we do discuss that public records exception. But I want to be clear that if a public record doesn't meet the requirements of Rule 8038 and it's offered for its truth and therefore is hearsay, it is not going to be made magically admissible just because it satisfies our rule here, Rule 1005. So remember and put into your notes that Rule 1005 is going to work in concert with the hearsay exception in Rule 8038. Okay, Rule 1006 next. This is a special rule that allows into evidence charts, summaries, or calculations to prove the content of a whole body or group of writings that are particularly voluminous. So this is obviously a rule that's designed to make it easier for a trier of fact, say a jury or even a judge, to take in and use this kind of voluminous information. All right, so for this rule to come into play, though, the body or group of originals has to be determined to be so voluminous that they cannot conveniently be examined in court. And the rule is clear that the originals must be made available for the other party or parties to examine at quote-unquote a reasonable time and place, which makes sense. Also, the court here is going to have discretion to order all of those underlying documents produced actually physically in court. And definitely watch out here for something else. All of the materials that the summary or chart is based on have to be themselves admissible independently in order for Rule 1006 to allow those into court. So any part of a summary that is shown to be based on inadmissible material can't be allowed in the summary. And the whole summary is in fact going to be kept out of evidence unless only the admissible portions can be separated out for admission. So this rule is actually used quite a bit. And in a lot of cases, it's used when we might not think the evidence would actually rise to the too voluminous to be examined in court threshold. For example, classic example here is courts have admitted charts to summarize as few as 20 drug transactions in a drug case, say when the underlying evidence consisted of just hotel receipts and phone bills, for example. And then I also have a chart that I show you in PowerPoint 7 from the Whitey Bulger trial, which is related to the Bucky Barrett case in the book. I have a chart that shows the particular branch of the mafia that Whitey Bulger was connected to. So charts that show organized crime players and how the government connects them all up, that's another common use of this summary rule 1006. And a couple other things about charts and summaries. It's logical that they are particularly necessary and consequently more likely to be admitted when the underlying material is very complicated or technical, or when there's a sequence of events that would be confusing if it wasn't laid out in order for the fact finder. So if a summary like this is accepted by the court under Rule 1006, remember, it's actual evidence in the case, officially admitted as evidence, so it can be taken to the jury room with other tangible evidence. And this stands in contrast, for example, to a situation where a chart or summary might be allowed to be put up, say, on an easel or a video screen in court during a particular witness's testimony to help explain the testimony. And in that situation, the chart or summary isn't automatically admitted as actual evidence, wouldn't be allowed for the jury to take it to the jury room. So if you can get your summary admitted here under Rule 1006, there's an advantage there, because if you have a jury trial, the jury is going to be able to actually take that with them. Okay, next, I like this diagram of the best evidence triangle. To me, this is a good way of understanding that Myers case on page 670, which is a little bit hard to follow. That case is, I think. So the idea of the triangle is that the question, the kind of question that was relevant in the Myers case, i.e., in that case, the question was, well, were they trying to, quote unquote, prove the contents of a writing with testimony? That question can actually be dealt with this triangle by asking whether it's necessary to go through the writing to get to the conclusion. So if you can get from the person's testimony offered to your conclusion without going through the writing itself, then the best evidence rule doesn't apply. If, on the other hand, it is necessary to go through the writing, then the best evidence rule applies. Okay, so keep that in mind now as we talk about the Myers case next. Okay, so Myers versus the United States. This is a 1948 DC Circuit case, and this was a prosecution for subornation of perjury. So they're prosecuting Myers here. So the defendant, Myers, is accused of encouraging Lamar to lie under oath to a Senate subcommittee. And the prosecution introduced oral testimony at trial by its witness, William P. Rogers, about what Lamar had said at this Senate subcommittee hearing. And why was Rogers offered as a witness? Because Rogers attended the hearing and watched Lamar's testimony. Okay, so the court held here that it wasn't an error by the court to admit Rogers' oral testimony about Lamar's testimony at that hearing, despite the fact that there was in existence a transcript of that hearing. And the court said, look, it's fine here to have Rogers just testify about Lamar's testimony instead of presenting that transcript, because the government was not attempting with Rogers' testimony to prove the contents of the transcript. Okay, Rogers was testifying about what Lamar said, not what was in the transcript of what Lamar said. The government, in fact, in the case, did introduce the transcript also into evidence. It, in fact, produced both the transcript and Rogers' testimony about what Lamar had said at the prior hearing. So here, if the best evidence rule had applied, the government wouldn't have been able to use oral testimony in addition to the transcript. It would, however, have been able to read the transcript to the jury, or even have an actor play the role of the witness while being questioned with the questions and answers from the transcript. But as you saw, the best evidence rule didn't apply to Rogers' testimony here, the testimony of eyewitness Rogers. All right, now, like I said before, in this case, the government put in evidence both the transcript of Lamar's testimony and the testimony of Rogers about Lamar's testimony. Maybe it could have been argued here that if, in fact, there's no difference between the transcript and the testimony of Rogers about what happened at the hearing, then Rogers' testimony was a waste of time under Rule 403. But in terms of the best evidence rule, there was not a valid objection here because the best evidence rule did not apply. Okay, So this Myers case is a great case for some evidence hearsay review. So some of you might have actually thought of this question. Wait a minute, how does this evidence about something that was said by a witness during a prior trial get past the hearsay rule? How could Rogers go in and testify about something Lamar said? Isn't that an out-of-court statement offered for its truth? Okay, so let's go over some possibilities. Maybe it gets past the hearsay rule because it's an admission, a statement of a party opponent. Remember, that's exempted from the hearsay rule by 801D2A. But no, the witness, Rogers here, was not the defendant himself, right? He's not a party. The defendant, Myers, was accused of suborning the perjury of Lamar, who is the declarant here, and Lamar is the one who is testifying. So this is not going to be a personal admission, the out-of-court statements here, not a personal admission. Okay, how about under the former testimony exception, one of those exceptions under Rule 804B for out-of-court statements of unavailable declarants? No, even if there was a showing here that Lamar, that out-of-court declarant, was unavailable, testimony about his prior testimony is not going to get in under the former testimony exception because that exception requires that there have been an opportunity by the current adverse party to cross-examine that declarant, and here there wasn't. So that 804B1 exception for former testimony wouldn't apply here. How about this one? A co-conspirator's statement. Maybe this might work. There probably was a conspiracy here between our defendant Myers and Lamar, the person who was testifying. After all, Myers is being accused of suborning perjury of Lamar. Okay, maybe therefore that testimony could be shown to be in furtherance of the conspiracy. And we know that the defendant, Myers here, doesn't have to be specifically on trial for conspiracy in order for evidence to be admissible under that rule. But some of you might have thought of the answer that the testimony being described by Rogers is not even hearsay at all. And I would agree with you because the government is not offering this testimony about Lamar's testimony for the truth of the matter asserted, right? In fact, the government is offering the testimony even though it's going to show with other evidence that the testimony was completely false. So it's not offered for its truth. Lamar's testimony not offered for its truth, those statements. And lastly, a somewhat related justification that could be mentioned by a lawyer here. What about the argument that the testimony about Lamar's statements is offered for the alternative lipsy purpose of recounting legally operative language? I think this might also work. One of the elements of proving that someone suborned perjury is proof that perjury was in fact committed. You commit perjury by saying false things. So the allegedly false testimony by Lamar could maybe be described here as legally operative language and hence not hearsay, not offered for its truth. Okay, that's the end of video lecture 1.